This matter has a long, litigious and unending history which has been highly publicized in the print, electronic, radio and television media since investigations into the arms deal commenced close on 2 decades ago. This matter has hence been the subject of much public interest and debate amongst many. Mr. Zuma's matter has passed through the hands of all national directors, acting national directors and deputy national directors of public prosecutions in one way or another since the investigation into Mr. Zuma's alleged unlawful conduct first commenced by the National Prosecuting Authority's defunct Directorate of Special Operations. I would thus like to take the opportunity today to inform the nation of my decision in relation to representations I received from former President Zuma on 31 January 2018 in terms of the provisions of Section 179, subsection 2 of the Constitution to reconsider the decision to indict him on 16 charges of an 18-charge indictment. Mr. Zuma, if you would recall well, was indicted on 28 December 2007 on the following charges: 1 count of racketeering, 2 counts of corruption, 1 count of money laundering, and 12 counts of fraud. On 10 February 2009, Mr. Zuma's lawyers submitted written representations to former Acting National Director of Public Prosecutions, Mokotedi Mshe SC. On 6 April 2009, Mshe SC announced his decision to terminate the prosecution of Mr. Zuma. The very next day, on 7 April 2009, the National Prosecuting Authority withdrew the charges against Mr. Zuma in the Durban High Court. Mshe SC's decision of 6 April 2009 was taken on review. On 13 October 2017, the Supreme Court of Appeal declared Mshe SC's decision to terminate the prosecution of Mr. Zuma as irrational. The indictment served on Mr. Zuma in December 2007 thus stood. Mr. Zuma submitted representations to me in respect of the self-same indictment. After the judgment of the Supreme Court of Appeal, I appointed a vastly experienced prosecuting team to peruse the evidence and advise me on Mr. Zuma's representations. The team comprises advocates Moiponi Noko, the Director of Public Prosecutions of KwaZulu-Natal, Lungi Mshlati SC, the Director of Public Prosecutions of the Eastern Cape, Billy Downer SC, a Deputy Director of Public Prosecutions in the Western Cape, Raymond Matenjwa, a Deputy Director of Public Prosecutions in the Office of the Priority Crimes Litigation Unit, and Alnisha Kutsia, a Deputy Director of Public Prosecutions and Regional Head of the Specialized Commercial Crime Unit in the Free State. I would like to thank the team for their input and recommendations which I received on 23 February 2018 and which I considered, along with the evidential material, representations and accompanying documentation. Mindful of the extraordinary long history of this matter, I always remain committed to bringing this matter to finality soonest. In fact, my spokesperson had on numerous occasions publicly recorded that I would like to announce my decision before the end of February 2018. However, this was not to be due to a commitment I made to an NGO to provide them with a 2 weeks notice of my readiness to announce my decision. That period, or notice period, lapsed yesterday. Earlier today, I notified Mr. Zuma in writing through his lawyers of my decision. Mr. Zuma's representations, broadly speaking, largely relate to allegations of a prosecution characterized by prosecutorial manipulation, impropriety, fair trial abuses, prosecutorial misconduct, deliberate leaking of information to the media, and irrational decisions made by various national directors and/or acting national directors of public prosecutions, along with inexplicable delays for approximately 15 years in bringing his matter to trial. Mr. Zuma, in addition, disputes all the allegations against him and records that he lacked the requisite intention to commit any of the crimes listed in the indictment. These allegations Mr. Zuma firmly places at the door of the National Prosecuting Authority some former national directors of public prosecutions, acting national directors, some in the leadership of the NPA, and some prosecutors and investigators. In this regard, justice must not only be done, but must also be seen to be done. I am mindful that everyone is equal before the law and enjoy the rights to equal protection and benefit of the law. Similarly, the National Prosecuting Authority, in executing its constitutional and legal mandate, will ensure that alleged perpetrators of crime will be prosecuted without fear, favor, or prejudice, irrespective of their station in life. On the facts of this matter, and in the interests of transparency, the interests of the administration of justice, and in the interests of the National Prosecuting Authority, I am of the view that a trial court would be the most appropriate forum for these issues to be ventilated and to be decided upon. After consideration of the matter, I am of the view that there are reasonable prospects of a successful prosecution of Mr. Zuma on the charges listed in the indictment served on Mr. Zuma prior to the termination of the matter by Mshe SC. As a result, Mr. Zuma's representations are unsuccessful. The Director of Public Prosecutions, KwaZulu-Natal, will facilitate the necessary processes for Mr. Zuma and his co-accused to appear in court. Lastly, an application for the permanent stay of the prosecution of Mr. Zuma has recently been filed in the Cape High Court by an NGO. I, along with the National Prosecuting Authority, have been cited as respondents in this matter. I have instructed the State Attorney to brief Senior Counsel to oppose this application. Members of the media, ladies and gentlemen, this then concludes today's announcement.